Good morning. Hello, Patricia.
Hi there.
And welcome to everyone. Thought we'd call the meeting order and start by, we have two new board members. And I thought we could ask them to introduce themselves, but we could also, for their benefit, each introduce ourselves. So I can start and we can kind of either one way or the other go around. So I'm Rowan Wilson. I am the chair of the board and I am the chief judge of the state of New York and sometimes of the Court of Appeals as well.
I'll say a little bit more because I think we all know who the chief is. Head of the board for a while, but I'm Diane Renwick. I'm the presiding justice of the Appellate Division First Department. For the Appellate Division, many years ago, of course, when I practiced, I was in the state Legal Aid Society in the Bronx Criminal Defense Division, and then in the Federal Defenders. And so I think those two experiences relate to this board. And also in the First Department, we have both the ACP 18B family and the section and the criminal defense section. So we supervise and not supervise, but oversee that. And it's, I think, important to be on this board to hear about all that goes on. Prior to Indigent Legal Services, of course, we did our own sort of assessment and best practices. So I know that the head of that division was very happy when many years ago the Indigent Legal Services came on to sort of, have a statewide system, and also in terms of stats and keeping stats, which is so important to be able to figure out how we, give the services to the right person. Anyway, I'm really happy to be a part of this board.
Hi. Wasn't sure. My name is Jill Caperno, and I was a public defender with the Monroe County Public Defender's Office for 35 years. I'm currently with Empire Justice Center working in the area of police reform. And it was an honor to be invited to this board and to participate in this board, and I'd like to welcome the new members.
I'm Burton Phillips, counsel to the New York State Office of Indigent Legal Services, and very happy to meet the new members today.
Good morning, everyone. My name is Eric Walter. I'm Chief of Staff to the Chief Administrator of the Justice Office in Seagull.
Nice to meet you. My name is Crystal Bolt. I am always at a distinct disadvantage in these meetings. I'm the only non-Esquire in the room. So I'm a county administrator. I'm a county administrator in Ontario County. I was formerly the county administrator in Washington County. So I've had the distinct privilege of working with 2 of the 5 settlement counties and have argued and worked with Patricia over the last 10 years. She wins every time. But she was kind enough to think of me for this position to represent the counties. I'm representing not only Ontario County, but all of the counties at the table. And appreciate it and welcome to the new board members. Thank you.
Cesar De Castro, new board member. Thanks for everybody for being so kind. I guess my background is I was a staff attorney out of law school in the Second Circuit, doing mostly a lot of criminal justice issues. I left there for the DA's office and was there for about 6 years. After that, I entered criminal defense practice about 2008. I was at a couple different firms, and in 2012, I started my own practice. I've been doing indigent defense work since about 2010. I'm on the panels for the Eastern District and Southern District of New York, mostly so I'm in federal court with respect to my indigent defense. I do private and public work, and I'm on the Capitol panel in the Eastern District, and so I'm really well versed in the issues of the needs of indigent defense. I have lots of needs myself in my practice, and so I hope I can provide a perspective to everybody, that perspective. And then other than that, what else could I say? Got 2 little girls that we were discussing, and I'm a very active parent. It's a big part of my life and a big part of, I try to bring it to practice as well, so that the courts understand that we're humans too and we have lives, and our defenders need to be seen that way as well.
Thank you. Welcome.
Okay.
Carmen Saparic, and in a former life, I was a judge for 34 years, first in criminal court and then New York County Supreme. And ultimately, I spent 19 years on the New York State Court of Appeals. Um, And now I'm of counsel at law firm of Greenberg Traurig. Unfortunately, I'm not doing any criminal work now. It's mostly civil litigation, but I do appeals and expert opinions on New York law for cases that are pending in foreign jurisdictions. That's pretty much the scope of my practice now. But I've been on this board for the last 10 years. It's been wonderful to be on this board. I was recently reappointed. 'Cause originally I was appointed by Governor Cuomo and have been reappointed by Governor Hochul. So I don't know if my future is on this board, but I'm still here. I'm glad to be here. I welcome my friend Judge Diane Renwick and Mr. Castro. I'm happy to meet you as well. Mr. Castro.
Good morning. My name is Mindy Jang. I am the ethics officer for the board and liaison between OCA and the board.
Okay, the first item of business is the approval of minutes from April 2nd, which are attached. A motion? Second?
Second.
Okay, all in favor?
Aye.
Those are approved.
I don't know if I have to abstain, so I wasn't here.
They look good here. Next item is the overview of the state enacted state budget, which Tricia is going to lead us on.
Sure, thank you. And I've instructed Burton that if I'm hard to hear, because I'm appearing virtually, that he is free to interrupt and take over for me. So as a quick reference point, ILS's budget is set forth in two budget bills, the state operations budget and the aid to localities budget. So I'll talk about each of those. The state operations budget is the funding needed to operate the ILS office and to pay our staff. Just a quick spoiler alert for the what happened with the final enacted budget is that it includes everything that we need. So as background, we requested with this board's approval, $8.6 million for our state operations budget with three goals. One, to continue the level of personnel and non-personnel funding needed to run our office. Two, to account for a 3% general salary increase for fiscal year 25-26 for all of our staff. And three, to add two new positions, an administrative assistant for our research unit and an organizational development specialist. At the September meeting, when the board approved our request for our state operations budget, you noted the value and importance of the organizational development specialist position in supporting the work that we're doing at ILS to promote the values of diversity, equity, and inclusion, and to build an office culture that honors the contributions and experiences of all of our staff. The final enacted budget is less than what we requested at $8.4 million, but it is enough to meet all three of our objectives, including the two new positions. The difference between what we requested and what we were finally appropriated is a result of different fringe rates. Fringe ended up being less than we had initially thought it was going to be. I want to thank this board's support for our state operations budget request, because I know it was that discussion at the last board meeting that really helped to ensure that the final enacted state operations budget does fund what we need, including the two additional positions. So I'll move on to our aid to localities budget, the second budget bill. Our budget request with this board's approval was $501.8 million with these goals. One, to continue full funding for the Harrell Settlement Initiative statewide to improve the quality of public criminal defense. To continue the funding needed to reimburse counties 50% of their expenditures for the ACP rate increase. 3, to increase slightly the funding needed for the ILS program, which funds our non-competitive distributions as well as some competitive grants. And 4, to devote the funding needed to do in family court what we've been doing in criminal court, by appropriating $50 million for improved quality representation in family court with the goal of reaching $150 million in 3 years. Unlike the state operations budget, we did not get everything we asked for, but we did make improvements over last year's enacted ILS aid to localities budget. And Burton will describe in more details, but we were appropriated the full funding needed to continue the HH settlement statewide, and the full fund, as well as the full funding needed to reimburse counties for their for 50% of the expenditures they incur for the ACP rate increase. We did not get an increase of funding for the ILS program. It remains constant at what it was funded last year, but Burton will tell you our strategy for addressing this. And as for the family court funding, we did not receive the $50 million we requested, but we did receive an appropriation of $25 million, which is $4.5 million more than last year's $19.5 million. And to add further context, the $25 million that was appropriated this year is 10 times the $2.5 million that was appropriated to ILS in fiscal year 21-22, which is the first year that we were appropriated a designated amount of funding for improved family court representation. So we're making progress. And even though it's not everything we need, we are building upon the momentum, and we're going to continue to build upon the momentum. And Burton will tell you what this progress means in our efforts to improve the family court representation. And he'll tell you this when he discusses our proposal for how to allocate the ILS appropriation. I do want to talk about one other part of the budget legislation. You know, the budget also does include what's commonly called Article 7 bills, or bills that have policy legislation. And this year's enacted budget includes one policy initiative that will have a meaningful impact on the work that we do at ILS. Specifically, the Public Protection and General Government Article 7 bill includes, in Part W, significant changes to Criminal Procedure Law Article 182, which allows for virtual court appearances in criminal matters. Now, the current CPL 182 allows for virtual court appearances in criminal matters only in certain counties. The changes extend this so that all counties statewide and New York City can conduct virtual court appearances. In expanding the ability to conduct court appearances virtually, the new article CPL 182 establishes important guardrails and guidelines. For arraignments in particular, the new legislation makes it clear that arraignments are to occur in person. That's the default, though it lists 4 exceptions that allow for virtual arraignments with the client's consent. The legislation also changes ILS's implementing statute, specifically Executive Law 832-4, to conform to this particular change in CPL 182. I'll be honest and say we were surprised by this legislation. It was not in the executive proposed budget, nor was it in the Assembly or the Senate one-house bills. So we haven't had a lot of time to look at it. We're still in the process of reviewing it and getting input from public defense providers across the state on the implications it will have on their practice and the potential implications for the quality of representation. Because we know, based on our experiences with virtual court appearances during the COVID pandemic, that virtual court appearances do impact the quality of representation. We do intend to issue a statement on this new legislation, and the input that we receive from providers will inform the details of the statement. But I can assure you that the statement will emphasize that decisions regarding whether or not to have a particular virtual court appearance is a fundamental decision for the client, a decision to be made by the client after a meaningful and confidential meeting with counsel that allows for the client to fully assess the pros and the cons of having that particular court appearance occur virtually. We also intend to monitor the implementation of this new legislation to determine it is being implemented in accordance with this principle of centering the client and the client's decision. And if not, if there are changes to the legislation that need to be made. So that's the overview of the final enacted budget. And I just wanted to see if people, board members had any questions or comments.
I have a question. Will the defense attorney be in the same space as the defendants so that they can consult privately without being on video, or is there accommodation for that?
I think that's something that we're trying to look at. My understanding is that that will change depending on the particular circumstance of that court appearance. So that's not that won't necessarily be the case. And, you know, I think that's something that we have to consider going forward. So for example, you know, would that be important for us to say if that's an option, that's an option that the attorney should always elect, or that option should inform the client's decision on whether or not to engage in a virtual court appearance.
Thank you.
The new software that you're piloting has the ability for counsel to create sort of private breakout rooms that, and they can do that without the court actually having intervened to do that. We're anticipating rolling it out, you know, whether fully, whether it gets to the town and village courts, though, I'm not certain. So that, you know, this may end up being a bifurcated issue.
Patricia, I've gone through it like 5 or 6 times. I think I had my head wrapped around it. I think kudos to you and the team for what I see as some creative reallocation of funds and trying to streamline and standardize contracting in the localities budget detail that you guys provided. I think in general, the indigent legal services funding to counties is matched in complexity only by the DSS funding streams. And so a lot of this, if I'm understanding all of this correctly, a lot of the steps that you're proposing will make it much easier for counties to navigate. I hope that means that it's going to make it easier for your grant staff as well, but just thank you for that. I think all the steps I read and annotated, I felt like, oh, okay, this is going to be more streamlined. Things are going to be on the same cycle. This is going to be much more intuitive for counties. So thank you. And I think that's a really good step in the right direction for local providers.
Yeah, and that's those details are in the allocation plan. So I'll be talking some more about that.
Oh, sorry.
Go ahead. Oh, it's okay. But I'll talk with the rest of the board too about some of the benefits of what we're proposing, both for us and for the counties and providers.
Though I can say, Chris, I think you've previewed the goals and the intent of the allocation.
I got ahead on the agenda.
Yep. Any other questions about the enacted budget?
Okay, we can move on to Burton and the budget allocation.
Okay. So one of the responsibilities of the ILS board pursuant to Executive Law Section 833 Subdivision 7 is to accept, reject, or modify recommendations made by the Office of Indigent Legal Services regarding the allocation of funds and the awarding of grants from the Indigent Legal Services. So the allocation plan that was included in today's meeting materials are our recommendations for dispersing funding that was included in the newly appropriated fiscal year 25-26 state budget, which Patricia just spoke about. The appropriations bills that comprise the New York State budget break ILS's aid to localities funding down into 4 distinct programs. And those are the programs that Patricia just walked through. So I'm going to discuss this allocation plan going program by program as well. The general purpose for each of the 4 programs is defined in the appropriation language, and that establishes on a broad level what the funding can be used for and how it can be dispersed. Within each program, though, there is discretion, and this is where the board's discretion comes in, to determine via this allocation plan how, to whom, in what amounts, and for what specific purposes the funding should be dispersed. That said, there are some funding obligations where we have little to no discretion, and I'll note those as we go through. And even where we do have the discretion, once the allocation plan has been approved by the board, ILS needs to receive approval for every proposed contracting action from both the State Division of Budget and the Office of State Comptroller. So we have kept that in mind as we've developed this proposal to have it be something that if the board approves it, is likely to also get the approvals that are necessary from both DOB and from the Comptroller's Office. So I'm going to start first with the Indigent Legal Services Program. That's the oldest of our programs. As Patricia noted, it's funded at $81 million this year. That is the same appropriation amount that we've had for the past 15 years. As Patricia noted, we did request a 6% COLA for this program when we submitted our budget request to DOB back in the fall, but we did not ultimately end up getting that. Now, the appropriation language for this program dictates that the funding goes to counties in New York City, and it can be used for all public defense covered under Article 18B of the county law. So that is both family court representation as well as criminal defense. Just about half, just a little less than half of that $81 million, there's really no discretion on, because by statute, we have to disperse $40 million to New York City out of that $81 million. So that is something that we will do in the next few months. We disperse that $40 million to New York City. Our understanding from talking to New York City is that that funding is used to offset part of their cost of the assigned counsel vouchers. For the remaining $41 million, it is then split between our quality enhancement distributions, which I'll refer to as our ILS distribution contracts, and then a handful of other grants that I'll talk about in a moment. The ILS distribution contracts are non-competitive grant contracts that we have with all 57 counties and New York City. To date, the amount of funding that each locality has received has been the same since 2010. Hence, are seeking that 6% COLA, which even that is very modest and far overdue. I think, as Chris can certainly attest to, and I think Jill probably has experience with as well, the fact that these contracts have remained, the grants have remained flat for the past 15 years means it's effectively been a cut. So, programs and positions that have been funded on these contracts for the past 15 years have either met a ceiling where, maybe salaries can't exceed, what was originally budgeted 15 years ago, or counties and providers have had to figure out other ways to fund some of the initiatives on those grants. These grants, again, can be used for all Article 18B public defense. So there's a lot of flexibility that the counties have with these grants. In this upcoming year, 2026, all 57 counties in New York City will be in the third year of the current 3-year ILS distribution contract, which we've numbered as distribution number 14. In this allocation plan, we are proposing a $3.2 million increase to the third year of those contracts, with the intent to continue that increase in the coming years. So that would effectively be just about a 10% increase to every county's contract. As I noted, the overall appropriation for this program didn't increase. So the answer to how we are able to increase the distribution contracts lies in our plans for the remainder of the ILS program. So in prior years, after that $40 million statutory distribution to New York City has occurred, and after we've accounted for the ILS distribution contracts, the remainder of the ILS program funding was used for a number of different grants that were issued on a staggered basis over several years. So I'm going to just as quickly as I can, talk about those grants now and explain some of the proposed changes that will allow us to increase distribution funding. So the first is our Counsel at First Appearance, or CAFA grants. Prior to the statewide expansion of the Harrell Herring settlement reforms, these were competitive grants that were awarded to 27 counties. When Executive Law 832-4 was enacted, expanding the Harrell Herring settlement reform statewide, ILS factored in the continuation of this funding when we were determining the amount of statewide funding that each county needed. So because the CAFA funding is now foundational to the statewide funding, these grants are now issued on a non-competitive basis. The current 3-year CAFA contracts end at the end of 2025. So our proposal is to issue a new 3-year CAFA contract starting January 1st, 2026, but moving the grant from the ILS program to instead into our statewide implementation program, which I'll talk about shortly. And we would do that by reallocating unspent, reappropriated funding from prior budget years that still exists in that program. Changing the program through which we fund the CAFA grants would have no direct impact on counties or providers. That would really be sort of a back end change on our part. But it would free up about $5.7 million annually in the ILS program that we could use to increase the award amounts for the distribution contracts, as well as other grants that are funded by the ILS program. There's a number of reasons that we lay out in the memo that we recommend doing this. I won't rehash them here, but it makes a lot of sense both administratively and as a way for us to sort of think creatively about how we can build in increases to those distribution contracts that we know are sorely needed by the counties, while not reducing any other grants that we currently issue. The next of our grants that we fund out of the ILS program are the Upstate Quality Improvement and Caseload Reduction contracts. Like the CAFA grants, these are formerly competitive grants that became non-competitive because they're foundational to the calculation of the statewide funding. Unlike CAFA, but similar to the ILS distributions, these grants can be used for all public defense, both family court and criminal. I don't think I mentioned, but I should have mentioned, the CAFA grants are for criminal defense only, cannot be used for family court. The current 3-year upstate quality contracts end a year from now at the end of June 2026. And all but about $200,000 of those current contracts have been previously allocated by the board in prior years. So for this year, we're proposing allocating roughly $950,000 of this year's appropriation to fully fund the remainder of the current contracts and to extend the current contracts by 6 months through the end of 2026. And to Chris's point earlier, the advantage of doing this is twofold. As a general rule, there is an advantage both to counties and to ILS to having contracts run synchronous to the locality's budget year, which for the counties is the calendar year. For New York City, it is July through June. And so we have New York City contracts often running from July to June for that exact purpose. And we have several contracts that do run on the calendar year for the rest of the counties, but some of our contracts, like this one, are not currently synced up with the county budget year. We also have an interest in consolidating our grant contracts where it's practicable to do so, to reduce the number of open contracts that we have with each county at any given time. So by extending the upstate quality contracts for 6 months, we will then make them synchronous with the distribution contracts. And very likely then in next year's allocation plan, we would propose combining the upstate funding with the distribution contract funding, since they can both be used for family and criminal. Every county has a distribution contract, 30 counties have upstate. It just makes sense to fold that money in and have one less contract for both the counties to juggle and for ILS to have to administer. The next grant in the ILS program are our regional immigration assistance centers. These are increasingly important over time. This is a statewide network of ILS funded programs that are staffed by attorneys and other professionals with extensive expertise in immigration law. They provide public defense attorneys with advisals in family court, criminal, appellate, and post-conviction matters as to potential immigration consequences of the cases. We have 6 REACTs across New York State in 6 defined regions. 5 of the REACT contracts are awarded on a competitive basis. The 6th for New York City is awarded non-competitively because New York City is the only entity that would be eligible to have the contract. The current 3-year contracts are fully funded by prior year allocations by this board. So we don't need to do any additional funding for the current contracts, with the exception of New York City. New York City's contract is a year ahead of the other 5 and ends in December of this year. So we are proposing an allocation of $585,000 from this year's appropriation to extend the contract for New York City by 1 year and increase the award amount by 6%. That would sync up the New York City contract with the other regions, and we anticipate similarly proposing 6% COLA increases for the other 5 regions in next year's allocation plan. So those are the actions that we're recommending this year on the remainder of the grants that are currently funded by the ILS program. If the recommendations are approved by the board, starting next year, the allocation plan for this program becomes much, much simpler. I know I just went into a lot of detail. We won't need to go into that level of detail next year if this is approved this year. And it's also sustainable on a year-to-year basis going forward, even with those increases that we are proposing for the distributions and the REAC grants, even if the overall appropriation for the program stays at $81 million. We hope it won't. We'll continue to advocate for increases where we can. But if we stay at 81 million, we're at least able to start to build in those increases. With the plan this year, though, if this is approved as is, while it's sustainable in the out years, it leaves us with about $6 million of unallocated funding this year that can essentially be thought of as one-time funding. So for that funding, we are proposing one-time office modernization and professionalization grants. So the idea here is this funding would be issued to counties for non-recurring office renovation, technology upgrades, and other office modernization and professionalization projects that will enhance the quality of representation that the clients receive from public defenders. This would be a pilot project of sorts for ILS, and if successful, could provide a blueprint for future budget years where we find ourselves with these sort of one-time budget surpluses. That concludes the first of the 4 programs. So I'm going to pause here for a moment to see if there's any questions so far.
Burton, I want to point out that Vince has a question.
Oh, sure. Thank you. Hi, Vince.
Hi, Bert. You can hear me okay?
Yes.
Okay, great. So on the upstate quality improvement grants,
Yes.
you indicate that the annual award amount, which is about 4 million, will go into the distribution contracts. But will that amount still be earmarked towards the 37 upstate counties that currently are receiving funding under that?
Yes, the idea there is that the amount of funding for each county would stay the same. So if they have the upstate funding, it would just get added to their distribution contracts. Counties that have distribution contracts but don't have the upstate quality funding would not see any additional increase. It's really just keeping everyone whole, but reducing the number of contracts.
Thank you.
Yep. Okay, I'll go to the second program, which is the Harrell Herring Settlement Statewide Implementation Program. I'm just going to refer to that as the Statewide Implementation Program from here on out. This program totals about $274 million. That is more than 3 times as large as the ILS program, and yet this is going to be much, much simpler. The appropriation language states that this is for criminal defense only. This cannot be used for family court representation. The funding goes to all counties in New York City. I do want to note for the first time this year, this is a combined program. It was previously 2 separate programs, one pot of funding for the 5 Harrell settlement counties, and then a pot of funding for the rest of the state. But now that the settlement period has ended and all of the counties, including the former settlement counties, are subject to Executive Law 832-4, it made sense to streamline that and have that all come out of one program. And here again, the proposed allocation for this year's $274 million is pretty simple because it's needed to support the continuation of 3 current grant contracts. The 3-year statewide implementation contracts held by 52 counties in New York City, 3-year settlement implementation contracts held by the 5 former settlement counties, and 3-year CAFA contracts that are held by 4 of the 5 former settlement counties. As I mentioned earlier, we are proposing adding a 4th grant to this program this year, and that would be the 27 CAFA grants that are currently funded by the ILS program. And we would do that by using $5.7 million reappropriated unspent funding for prior budget years. So in other words, this $5.7 million would not come out of this year's new $274 million, but rather from unspent funding that had been appropriated in prior budget years. And I'll pause there to see if there are any questions.
I have a question, and that is, if there's unspent funding being used for CAFA, but next year you don't have the same unspent funding and you have the amount that you've allocated, is that going to be a problem when it's looked at next year?
So we are still getting sort of the final numbers on what is going to be left remaining from the funding that was appropriated to support the first HH statewide contracts, which were the 5-year contracts with a phase-in over 5 years. Those contracts have now come to an end, including any extensions. So final claims for those are coming in. But from the numbers that we've run so far, there is an ample amount of unspent funding remaining, many more times, frankly, than what we will need to issue 3-year contract using that funding. I think we'll need to have further conversations about what happens with that rest of that unspent funding. Those are, conversations we'll have internally and with the board and think about going forward. But there is plenty for this year, and we've also spoken with our division budget team in advance of proposing this to the board, just to sort of get their confirmation that this would be feasible to do.
Thank you.
And they have.
You want to briefly explain why there is unspent funding?
Sure. So that first 5-year contract, this was a brand new program that was rolled out, and for a number of reasons, including the time that it took to start to get contracts in place with every county that was receiving this funding. And then once the contracts were in place for the counties to start to build the programs that were being funded by the contracts. Now, these are all cost reimbursement contracts. So even once the contract was in place, counties still needed to go through steps at the county budget level to make funding available to outlay that money and then get reimbursed by ILS for it. We know that there's some lag time when it comes to starting new programs, especially when it's creating new positions, especially where it is a government position. Chris, again, I'm sure could tell us some of the struggles it takes to get the approvals necessary to create new positions, go through a civil service process before we're even at the point of then trying to recruit and fill those positions. So there's some natural lag time that comes with that. In addition, the rollout of those 5-year contracts also coincided with COVID. And so there was a period of time, certainly in the middle of that rollout, where implementation was certainly slowed down in many counties due to local hiring restrictions and frankly, prioritization, I think, of important public health matters and funding. So for those reasons, not all of the funding ended up getting actually spent and claimed from ILS within the period of the contract. And we were able to extend contracts for the counties for an additional 2 years, but under the terms of the budget language itself, you could not extend those contracts any further. So what is remaining is now, there was no other way to extend those contracts further to allow continued spending. And I do want to pause there to just see if Patricia had anything else you wanted to add on that question.
No, I mean, we had, when we started the Harrell hearing settlement statewide implementation, we knew that there would be unspent funding because we knew that there would be that lag between, contracting and hiring and building the new programs. So some of that is anticipated. We didn't anticipate COVID, so that, as Burton said, also contributed to it. I would also say, though, that even though, the counties in the first contract didn't spend all the funding and that was anticipated, it still was meaningful for them to have it appropriated. Having it appropriated, having the budgets established within the counties, the confidence needed to build these programs. And so going forward, we have this track record now of ongoing funding. I think the trust now that counties have in that process and the availability of that funding is going to be meaningful going forward in ensuring that, that more of the funding is spent.
Yeah.
And helps with the legislature might want to reallocate that money into the general fund.
So, we did get reappropriation authority for that funding in this year's budget. So, we do continue to have that funding reappropriated, meaning we can find other uses for the funding. We certainly are going to remain cognizant of making sure that we are effectively using the funding. But this funding, these appropriations are coming out of the Indigent Legal Services Fund. So if the funding isn't actually spent, that means that the funding does remain in the Indigent Legal Services Fund for us to use for new appropriations.
I'm just worried about the legislature trying to put it into the general fund where they did that over.
Yes.
For litigation in order to stop that.
Yeah, absolutely. The third of our programs is the Article 18B Family Court Representation Program. I'll refer to that as the Family Court Program. As Patricia noted, we did end up with a $25 million appropriation. $19.5 million of that we are able to consider recurring funding, meaning the baseline going forward for this program will be $19.5 million. But the additional $5.5 million that gets us up to the $25 million, we have to treat this year as one-time funding. Like the ILS program, what we are proposing to do here on paper, and this is on pages 4 and 5 of the allocation memo, reads as somewhat complicated. What has made it complicated is the manner in which the program has been funded in the past and the decisions that we've had to make as a result of how it's been funded. It's increased year over year, as Patricia noted, which has been a good thing, but it's been an unpredictable combination of recurring and non-recurring funding. And so it's been very difficult to date to establish a consistent allocation plan. However, with this year's appropriation, we can do just that. We can finally establish a sustainable, ongoing, and predictable allocation for this funding. So what we are proposing to do here is, this is an amount, this 19.5 recurring is enough for us to start this year dispersing at least $250,000 a year to every county on an ongoing and non-competitive basis. So we would do that by increasing the award amount of counties' current family defense contracts to $250,000 a year if they're not yet at $250,000 a year. We will issue contracts of $250,000 a year to the 15 counties that don't currently have a family defense contract with ILS. And we are targeting the 5 highest need localities with an additional $1 million a year. What this will mean is every county will have a contract for family defense funding from ILS. So we can stop the time-consuming and unpredictable cycles of competitive RFPs for these contracts, which means that it will be much easier for the counties and providers to budget this funding in their county budgets in the long term, not have to worry if they are creating positions only to see a competitive grant disappear at the end of a 3-year period. And we can make immediate investments in the counties where we know the funding is most needed and can and will be used. So this is going to be sustainable in the out years if we stay at $19.5 million. But if we continue to increase the appropriations, which we certainly hope to do and will continue to advocate to do, we now have the contractual infrastructure to weave that additional funding into the county's contracts, and again, have them all in place on a non-competitive basis. So this will really set us up well for the future as we are able to get more funding through the budget process for this program. In addition to creating that sustainable funding between this year's appropriation and a partial reallocation of last year's appropriation, we also have enough one-time funding this year for us to increase the award amounts for our 2 current competitively awarded upstate model family representation offices. Those are currently held by Westchester and Monroe counties, and issue up to 4 new competitive upstate model family representation offices starting in 2026. So that's the rundown on the Family Court program, and I'll pause there again for any questions. Okay, and finally, the easiest of our programs, the assigned counsel program, increased rate reimbursement. Here, there's no real allocation decision to be made, but we will continue to disperse up to $92 million a year to counties in New York City to reimburse them for 50% of the 2023 increase to the statutory assigned counsel rates. That is the allocation plan for the board's consideration.
Any further questions or discussion?
What is the current amount?
For the assigned counsel program,
72?
92.
92?
Yep, 92 million.
No, I'm talking about hourly rate,
Oh, I'm sorry. I'm so sorry. $158 an hour.
158.
Yep.
Sorry.
If there's nothing further, we can take a motion.
All right, I so move that we accept this.
Second.
All in favor?
Aye.
Opposed? Great. Thank you.
Thank
Yep.
you.
We're still with, sorry, we're off to Patricia for the standards for investigation.
Sure. So at the last board meeting, the ILS board members heard from Kingston Faraday, Mandy Jaramillo, and Jen Chen-Yu, who are co-chairs of the working group that's developing the standards for the investigation function of interdisciplinary defense teams. And they described the goals of the standards as well as the process for development. I circulated it with the board materials, the standards, draft standards for your review. And so, obviously I didn't anticipate that you would have reviewed them prior to this board meeting. But we're hoping to have you review them prior to the September board meeting with the goal of discussing these standards at the September meeting and determining if we're in a position to have the board vote to approve them. So I ask that you do review these standards. If possible, I ask that you email me comments on the standards, comments, ideas, any suggestions, any edits that you think are necessary by August 15th, if possible, because that would give us an opportunity to, organize all the comments and organize all the thoughts that you have on these standards. And then that'll give us an opportunity to prepare for the September board meeting and give you an overview of what you all think about the standards. I will send email reminders before then and resend the copies of the standards so that you have them at your fingertips in advance of August 15th, just to remind you of the goal of getting your comments by them. I want to emphasize just how very excited I am about these standards. As Kingston, Mandy, and Jen told you, we've reviewed, across the country to see if any such standards exist, and they don't. There really aren't standards just for the defense function, the investigation function in public defense. And I think that's because for a long time, people have treated public defense investigations similar to law enforcement investigations, but it's very, very different, as you will see when you review these standards. So this is an opportunity for ILS to really be a leader across the nation on having standards that really are designed to both professionalize the investigation function for public defense and elevate its importance. So I want to just pause there, and see if anybody has any questions or concerns about, reviewing these and preparing comments by August 15th.
Guess I have one question, which is what form would you want comments and what's easiest for you all? I mean, sort of an administrative thing.
Yeah, we're so used to getting comments in a variety of different formats that we would really defer to what's easiest for you. and we'll be able to accommodate that. And the August 15th deadline will give us plenty of time to accommodate that. So if you want to write, comments on the standards themselves or send us a summary of them. Also, I did send you a PDF version. If you would prefer to have a Word version, I think that we could get that to you. If it's easier for you to write comments on that as well. So just let us know.
I would prefer Word version, but also I'm wondering, and I don't know if this is appropriate, if we could have a common Word version where we could see each other's comments, and that might prompt other ideas about what we're looking at.
I'm not quite sure exactly how that would work. Let me think about that, Jill, but in the meantime, I'll email each of you, all of you the Word version.
Thank you.
Vincent, you had your hand up.
Vince?
Yes, hi. So I just wanted to share that I'm very excited about the fact that the board is undertaken, or the office has undertaken this. In a prior life, I was president of the board of a assigned counsel program, and we had a system where we would, after attorneys on our panel had been on our panel for a certain number of years, we would do sort of a rescreening of them to make sure that things were going well and they were still appropriate to be on the panel and at the level that they were at. And my habit was to ask each of the lawyers that came in, tell us about the last time you used an investigator on one of your cases. And routinely on the misdemeanor panel lawyers, none of them had ever used an investigator at all. And on the felony panel, really the only ones who regularly used investigators were on homicide cases. And we did everything we could to try to encourage the lawyers to use investigators. And there just was a feeling among them that they weren't supposed to incur the cost. The judges would get upset about approving. And so, it took a long time to try to change that attitude. And I think having standards that say something like clients are supposed to have a team that includes an investigator, and it's supposed to be involved as early as possible. I just think that's a wonderful idea. So I'm excited about these, and I will look through them very closely.
Thank you. And what's even more exciting is now there's funding, statewide funding for investigative services. So, it's a combination of having the standard, specifying that this is an important part of the work, and then the funding to back it up.
Great. I think we're back to Burton and office updates.
Yep, this will be a quick rundown. Since the last meeting, we onboarded one new staffer for ILS, Jack Notar, who joined us as Criminal Defense Representation Counsel for Region D, which is the Adirondacks North Country region. We will be onboarding in coming weeks 2 new grants unit employees, Tim Clark, an auditor, and Ying Liu, who is an assistant grants manager 1. We have BDAs or budget director approvals pending. So these are offers that have been accepted and now working their way through the state approval process for a contract manager with our grants unit, a Western New York Regional Support Center Family Court Counsel, and the tenure-based salary increases for ILS staff that Patricia mentioned earlier. We are actively recruiting currently for the attorney in charge position in our Western New York Regional Support Center, as well as CDR Region G Council, and that's the Finger Lakes region. And we're also currently in the process of going through the necessary paperwork and approval steps to create the 2 new positions for which we were funded in this year's budget that Patricia mentioned earlier, the administrative assistant for the research team and an organizational development specialist. That's the update.
Unless anyone has anything else, take a motion to adjourn.
So move.
Second.